All right, I'll get moving with the webinar. Thank you so very much, everyone, for joining today's session on all about family-based green card. Today, I'm joined by Prashanthi Reddy. Prashanthi is a distinguished attorney. She's been in the field of immigration since 1997, admitted in the bar in New York. She's a member of the American Immigration Lawyers Association and the New York Bar Association as well. Including that, she is also an immigration chair for the National South Asian Bar Associations and immigration co-chair for the Federation of Indian Associations. She is currently actively involved in pro bono legal work as well. Today's webinar is a session where Prashanthi will be talking about family-based green card. We will be taking questions throughout the webinar, throughout the presentation. So if you have questions, we would encourage you to drop in your question in the chat window, and we will pick it up by the end of the webinar. So on that note, I would like to introduce you to Prashanthi. Prashanthi, over to you.
Thank you, Vishal. And we should get started on the topic. Just want to make sure everyone has been admitted.
Yes, Prashanthi, that is being done.
Okay, so starting with the immigration updates, we should start. Before going into the topic, I wanted to do a few updates. We should start with something that's not on the screen because it's really new. Yeah, just yesterday, after we prepared the presentation, USCIS announced that the H-1B cap has been met. So H-1B cap has been met as of yesterday. So they have used up all the 85,000 numbers catered for this year's cap. We were speculating about whether they'll have a third lottery, but that has not happened. So I guess this is it for this year's cap. But the good news is that in March, they will have next year's cap registration. And the way it works is that you have to first register for the webinar. Register for the H-1B cap. And then once you register, then they will pick your numbers from the registration and they will then run the lottery. Earlier, you had to file an entire petition. And once you filed your petition, then they would do a lottery and then pick the numbers from the filed petition. So in order to make it easier, a few years ago, they started this H-1B registration process whereby you just have to register with a $10 fee, which might go up next year. But as of now, it's a $10 fee. And you have to enter some basic information, such as the name of the employer, federal ID number, name of the beneficiary, passport number, etc. Whether it's a master's cap that you're registering for or a bachelor's cap. And you file that, and accordingly, it gets registered in their database, and then they do a lottery based on the registrations. This year, they might do something new. They've already published that that regulation, but it's not yet finalized. They're waiting for comments. But they want to pick the numbers based on the beneficiary's passport numbers rather than the number of registrations. So this way, if one beneficiary files 10 registrations, he'll only get one pick. He or she will only get one pick in the lottery. So that, I think, will be a more efficient way of doing things. But as of now, cap has been met. If anyone needs to come to the US before October 1st, because or if they don't get picked in the registration, you have to look at the alternatives to the cap. And, there are several alternatives such as an L1, a TN visa, etc., etc. You also have the E2 for Australia. Some limited circumstances, you can use the B1. So, you have some alternatives, but not too many. But it's important to know what those alternatives are if you need to come before October of next year. Another breaking news is the January visa bulletin. And the reason it's breaking is because there has been a significant forward movement for Indian nationals in the EB1 category. And the forward movement is in, as I said, the employment-based. Family-based has not seen much forward movement, but there has been some. And let's go into those details for the January visa bulletin. So for the EB1 category, also just to backtrack a little bit, there are two tables always in the visa bulletin. And for those who don't know what a visa bulletin is, there are a limited number of green cards available every year if you want to file a green card. And those numbers are released in October of every year. So the 2024 fiscal year has already started as of October. The new numbers have been released, and the visa bulletin shows you what dates they're working on. So if your priority date, so if you filed a labor cert, then the date that you filed the labor cert will be a priority date. If you did not need to file a labor cert, then the date that you file an I-140 or an I-130 in the situation of family-based cases will be your priority date. So you have to look at that priority date and see the visa bulletin to see and look at the two tables to see where your priority date stands. So if your priority date is, if the priority date in the visa bulletin is after your priority date, then you can go ahead and file. So your priority date has to fall within the priority date of the visa bulletin. Now, in the visa bulletin, you have two tables, as I was mentioning earlier. You have the final action dates table, and you have the dates for filing table. The reason they have created these two tables is so that you can file cases in advance before your priority date actually becomes available. But when they're expecting it to become available, they want you to file the application so that they can process it. And by the time they process it, they think that the numbers may become available. So the final action date is the final priority date availability. And if your dates are current based on the final action date table, then you will get a green card once your 485 is processed, provided that the dates don't retrogress while your 485 is being processed. The dates for filing table is the advanced table. So you're allowed to file even if you qualify under the dates for filing table, but you don't actually get a green card until those dates become final action dates. So, that being said, let's go dive into the table and see what the January visa bulletin looks like. So for the EB1 category, the cutoff date for EB1 India moves ahead to September 2021. Just go back to the previous slide. I'm not done. India moves to September 1, 2021. So that's a jump of 3 years and 8 months. So India, EB1 has moved up by 3 years and 8 months final action date. It was, 2019 earlier. So this is a really big jump. And for China, also the cutoff date advances to July 2022. For worldwide, all other categories, EB1 has been current, so it remains current. For EB2, there's a jump for India. It is moved up to March 2012 from May 2012. That's a jump of 2 months. So it's not as significant as EB1, but it's some movement, and that's good because there hasn't been any movement for a while. China moves ahead to June 2020, and there's a 3-month and 17 days move ahead for all other countries for EB2. Now you can move to the next slide. So going to EB3, January 2024 visa bulletin. EB3, not much forward movement for India. It's jumped by a month, still something. China has moved up to September 2020. All other countries moved up by 8 months. So that is, some forward movement. Now, when we talk about India, China, we are talking about people's place of birth. So you have to look at your place of birth and not your citizenship. You may be a Canadian citizen, you may be a US citizen, but always look at country of birth. So if you're born in India, then you come under the India quota. So for EB3, as I said, there is a 1 month forward movement. And EB4, there's a 4 month forward movement. EB4 is basically religious workers. So if you're a religious worker, then this is of importance to you. This is worldwide. So they're working on May 15, 2019 cases. EB5, also significant forward movement for Indian nationals. It's moved up to December 2020. EB5 is the investor visa category. And for those of you who don't know, EB1 is the intra-company transferee, so L1 based, multinational executive based. It's also for extraordinary ability, EB1, and EB1 is also for researcher category. So, and then EB2 is for people with a master's degree or a bachelor's plus 5 years. And EB3 is for jobs that require a bachelor's degree. EB3 other workers is for jobs that require less than a bachelor's degree. So, those are all the different categories of the employment-based that the employment-based visa denotes. So EB5, as I was saying, significant forward movement for India. They're on December 2020. There is another separate numbers reserved for EB5. This is new, set aside for jobs that are in high unemployment and rural areas. So they have set aside, I believe, 10,000 or so visas in that category. For China, EB5 also moves up to 2015. They are significantly backlogged because a lot of the EB1s are used up by China, not that many by India. For all other countries, EB5 remains current. Next slide. Now, going to the dates for filing chart, as I said, there were two tables, right? One is final action date and one is dates for filing chart. For the dates for filing, there hasn't been that much forward movement, except for EB1 India. Again, EB1 India has jumped to January 2021. So it's moved out by 1 year and 6 months. For China, also there's a forward movement of 5 months. It's moved to July 2023. And EB1 for dates for filing has remained current for all other countries. So if you're born in a country other than India and China, your date will be current. For EB2 also, if you have a spouse who's born in some other country other than India and China, their dates will be current as well. So EB2, the cutoff date for India remains at May 15, 2012, so it hasn't moved at all. For China also, it hasn't moved. EB2 cutoff dates for worldwide has moved by a small margin, 1 month and 14 days. EB3 category dates for filing chart has not moved. So no new people can apply. When the dates for filing chart don't move, that means, generally new people cannot apply into the system because they would have already applied based on the final action date, because the dates for filing are always ahead of the final action dates. China is jumped by 10 months, so that's quite a significant movement. All other countries remained at February 2023, so it's not current for EB3. EB4, all countries moved by 6 months, so that means new people can apply for EB4, especially if you're an Indian national. That is religious worker category. You can move to the next slide. And coming to a family-based category, since today's panel is about how to file a family petition, we have final action date table, and you can see here the only thing that I wanted to highlight for Indian nationals is F2A. F2A is if you're married to a permanent resident. Now this category has been current for many years, and then it became unavailable. Now the final action date has actually has at least moved up. by 8 months and 21 days. And this matches the other table as well, the dates for filing table. And if you see the other categories, so F1, F2B, F3, F4. So these F2B, F3, F4, what they are, we will discuss the different categories when we go into the main presentation. Next slide. For dates for filing chart for the family-based category, as you see, there's no change at all in any of the categories for any of the countries. Next slide. So just going a little bit into some FAQs published by USCIS, and this is of interest to everyone, to employment-based as well as family-based categories. The as of 2023, the number of available green card numbers, the annual limit for the green card numbers was set at 197,000. So every year the number changes because the unused numbers from the previous year's family-based categories are usually put into the employment-based category. So for the employment-based category, the numbers were set at 197,000, which was lower than previously, which was 200 and something thousand in the previous year. And that's because more visas, green cards are being processed by the consulates. During COVID, the consulates had shut down, so no visas were processed. So all those numbers were moved into the employment-based, and a lot of people living in this country, present in the US, were able to benefit from the rollover of numbers from the unused numbers for family-based cases, and also employment-based cases which were not being used by the consulate. So 197,000 in 2023 because the consulates had already started to open up and it was business as usual. There's been a set aside of 10,874 numbers for the EB5 category in addition to the regular numbers. This is in the this is for jobs that are in high unemployment areas. So TEAs, the 10,000 is set aside. And there's also a carryover of 6,939 for the EB5 numbers. So, and USCIS is saying that all the numbers have been used up. So no numbers have been wasted in 2023. They have been able to process all the numbers. In past times, numbers would be wasted because USCIS was not able to process them, and they would not be, then they could not be transferred into the next year. So that would just, the numbers would just be wasted. Now they're trying to process all the 485s that are being filed, and so there's a less wastage of numbers. Next slide. For 2024, the numbers available, you can see, are less, 161,000 compared to 190,000. So the numbers are getting lesser and lesser because there are lesser number of unused family-sponsored visa numbers. More of them are being used by the consulates. So this year we have, which starts in October, we have 161,000. And we have again for EB5 the same 10,875 extra visas for those jobs that are in high unemployment areas. So that's the update for the number of green card numbers available for this year, and they are USCIS has said that they will continue to use all these numbers so that none of them are wasted. Next slide. Another update, again, it's a good segue because we were just talking about how numbers are not available. And we just looked at the visa bulletin and we saw the huge waits. 2012, that means you had to file a labor cert in 2012 if you're an Indian national in order to, get a green card now. And, those numbers don't move every month. So it's not like, 12 years from now, you'll get your green card if you have a 2012, a priority date that's earlier than 2012. So our bill has been introduced. It's called HR 6542. The bill, the purpose of the bill is to amend the INA, the Immigration and Nationality Act, to remove numerical limitations on employment-based cases and to increase numerical limitations for family-based cases. This was introduced in the House on December 1st. It's a bipartisan bill, which means that it was introduced by Democrats as well as Republicans. But will it be a bipartisan voting? Very unlikely. The voting will take place on very partisan lines. So more than likely, the Democrats will vote for it and the Republicans will not. But unfortunately, because of the way the House and the Senate is split, so the House is controlled by the Republicans and the Senate is controlled by the Democrats. So, we will not be able to see, I don't think, unless the Republicans join in the voting, that the bill will be passed in the House to start off with, in order for it to reach the Senate. So the process is, it is first introduced, which has been done. Then it has to be introduced has to be passed by the House in a majority. They need a majority, and since the Republicans are in majority in the House, unless some Republicans defect, it's not likely to be passed in the House. If it is passed in the House, then it goes to the Senate, and then if it is passed in the Senate without any changes, then it goes to the President. If there are changes, then it has to go back to the House, and then they have to reconcile the changes, pass it again, and then finally it goes to the President. And then if the President does not veto it, because the President has veto powers, then it becomes a law. So that's the progression of any bill, and this bill as well. And as I said, unless both parties are willing to vote for this bill, it's not going to be passed. It's important that the bill be passed because these numerical limitations on employment-based cases are really killing the IT sector. And now with new technologies emerging and AI emerging, it's important for for America to keep at a cutting edge of these technologies and always have talent that will allow them to stay ahead of other countries in these new technologies, but they're not doing that. And so this talent that maybe has gone to school in this country, has worked for many years in this country, will leave and go elsewhere where conditions are more suitable and where they can get permanent residence. So it's important that this bill be passed. But politics always prevails over what is actually important for the country. So having said that, let's go to the next slide. Okay, so now we are in our main presentation, and we will take questions on all topics after this presentation, including any question you have. It doesn't have to be family-based. It can be a question on your green card, on your H1, etc., etc. So in order to understand family-based, we have to understand what is a family-based green card. A family-based green card is being able to obtain lawful permanent residence if your sponsor is a U.S. citizen or a permanent resident. If such those facts exist, then you are able to obtain a green card as well. There are two types of family-based petitions. One is immediate relatives, one is preference relatives. Next slide. So you're an immediate relative. You come into the immediate relative category if you are the spouse of a U.S. citizen, unmarried child under 21, minor child of a U.S. citizen, parent of a U.S. citizen, if your child is over 21 years of age. The advantage of this immediate relative category is that there's no capping on the numbers. So the visa bulletin that you see, that doesn't apply to immediate relatives. They can apply for green cards immediately without having to wait for the availability of any numbers. So there's no wait. And also certain bars to adjustment don't apply to this immediate relative category. So if you're out of status, for example, there is no bar on filing for a green card, unlike other any other 485 where, if you're out of status, you cannot apply. So that's a huge advantage of having an immediate relative to apply for you for a green card. Next slide. The other type of petition is the preference relatives. Preference relatives are many categories. The first F1, and by F1, F2, F2B, these are in order of how likely or how long the wait will be. So the first preference is unmarried children of US citizens who are over 21 years of age. So if you've become an adult, you no longer meet the criteria for child, and so minor child. So you go into, from an immediate relative category, you go into an F1 category. F2A, spouses and children of again, minor children under 21, unmarried, of lawful permanent residents. So if you are a spouse or a child of a green card holder, you come under F2A. F2A, we've looked at the bulletin. We've seen that there's been some forward movement, eight plus months. And I've also told you the F2A category for Indian nationals, there was, it has always been current. I mean, it has been current for many years, since 2019, I think. So it's unfortunately that it's become unavailable, but the numbers have moved up, and that's good news. F2B is unmarried sons and daughters of lawful permanent residents. So if you're 21 years of age and older, but you're unmarried, that means if you're a major, but you're still unmarried, you come under F2B. Married sons and daughters of US citizens come under F3. Brothers and sisters of US citizens comes under F4. That is, they have to be adult, of course, but that comes under F4. So F4 is the category which is most delayed, and F1 is the category that is least delayed. So it goes by that order. Next slide. So now that we know of the different preference categories, the different ones, how do we apply? Now, if you belong to a category where the visa number is not available or which is not an immediate relative, you have to first file an I-130. In order to file the I-130, you have to file an I-130 form. The form itself is called an I-130 form. You have to file that along with your, if you're in the US, then proof of status. If you're not in the US, then your passport. And then you would have to submit documentation to show the proof of relationship. That means it would be, depending on the type of relationship, it would be the birth certificate if you're related by birth, or it would be a marriage certificate if you're related by marriage. And you also have to meet the criteria for the I-130, which means that you should not be barred for any reason. It could be if you have a criminal offense, or if you are out of status, then you're not likely to succeed further moving forward on an I-130 application. So in addition to that, you have to show also that your sponsor is able to afford you. So is able to sponsor you financially as well. So there is something called the public charge rule, which we will go into later, but there's also a fee for the I-130, and there's biometrics that you have to take, and the fee for the I-130 varies. They keep increasing it, they never decrease it. And I-130 can also be filed online. So that's a new facility that they've provided. You can file by mail or also online. So that's the first step in a green card process, the I-130. It's called the immigrant petition. Next slide. So as I was saying, in order to file a green card, especially family-based cases, there's something called the public charge law. And this public charge law was much more stringent under the Trump administration. It still exists under the Biden administration, but it's less stringent. There are many public charges that have been taken away. So what is a public charge? Congress established that non-citizens' application for a visa or adjustment of status can be denied if they are found likely at any time to become a public charge. Meaning if they are found likely to be using government assistance, certain types of government assistance, then it's likely that they will not be approved. The green card will not be approved. The 485 will not be approved, and the immigrant visa will not be approved. Now, if you have already taken public assistance, it's very likely that you will be found to be likely to become a public charge in the future as well. So any past actions will also hurt you. So public charge basically determination is based on a non-citizen's likelihood of becoming primarily dependent on the government for subsistence, meaning for subsistence as demonstrated by either a receipt of public cash or assistance, for income maintenance or long-term institutionalization at a government expense, meaning health, for health reasons, if you have to be institutionalized, whether mental health or physical health, on a long term, and you are doing this at government expense, or you're taking cash from the government for sustenance, or you're taking income assistance from the government, again for sustenance. All this will be considered to be a public charge. Next slide. So this is generally looked at when you're filing for a green card, whether it be a 485 or it be if you're outside the country, then you're filing the I-130, and then you have to file the immigrant visa petition. When you're filing that, they will also look at this public charge rule. Of course, if you have a sponsor who is filing an affidavit of support for you, that to a certain extent will help the USCIS determine that you will not be a public charge, as long as the sponsor has enough money to sustain his family and you, and they meet the poverty guidelines. Then you may not be considered to be a public charge unless you have previously taken public assistance. Then even if you have an affidavit of support, the officer might consider you to be a public charge, and this is based on a case-by-case basis. Some people who are not, and by the way, public charge is also relevant to employment-based cases. It's not just family-based cases. So you have to meet this in employment-based cases also, but it's easier in employment-based cases because, the person is working. Your sponsor is always working in this particular situation because it's employment-based. Some people are exempt from these public charge grounds, and these are some examples: asylees, refugees, etc. People from Cuba and Haiti, etc. So next slide. There's a long list, and we won't go into that. So as I was saying, what are the factors to be considered when an officer decides whether public charge inadmissibility applies to you, and you will be found inadmissible, or you will get an approval. So what are the factors that apply to you? So for all applicants for adjustment of status who are subject to the public charge ground, USCIS must consider the certain minimum factors such as age, your health. When I say you, I'm talking about the beneficiary, the person who's applying for the green card. So if you are, for example, a parent, somebody's parent, and you're 70 years of age and you're in bad health, it's quite likely that they will consider you to have a high probability of being a public charge because you have no income, you're retired. So some of the minimum factors are age, health, family status, assets, resources, financial status, and your education and skills. Say you're not yet working, but you have a bachelor's in computer science. They will consider that to see, whether you'll be able to get a job or not. And, since you're highly skilled, that will be a positive factor, to be considered in your application. All these factors are relevant information is provided in the 485 form, and your medicals are required. Medical report is required, so they will look at that to look at the public charge determination, to make the public charge determination. Also, as I was saying, USCIS will consider the affidavit of support. An affidavit of support is required, Form I-864, and they will consider that also when they're approving your green card. So this applies to any kind of green card, not just family-based, employment-based as well. When you're filing a 485, these things have to be taken into consideration and cannot be taken lightly. So USCIS will also consider past receipt of public cash and assistance, as I was saying. If you've ever taken any of those, then you might automatically be considered to be a public charge. Even if you're an employment-based person, a dependent of an employment-based 485, you might be considered a public charge. So therefore, as a non-immigrant, make sure that you know what factors will work against you when you're filing a 485, and don't take that kind of financial benefit from the government. So that's why this particular section of the presentation is important, because it applies to everyone. Next slide. So these are some of the things that are not considered to be public charge grounds. So so we consider an applicant current and or past receipt of public assistance or income maintenance. Public cash assistance for income maintenance includes only the following. So the following are, those that will be considered to be public charge grounds. So if you take any of these, and again, there is a list, but these are the most important. So if you keep these in mind, if you take any of these, you will be considered to be public charge, and you will not get a green card. So SSI, Supplemental Security Income, TANF, Cash Assistance under the Temporary Assistance for Needy Families Fund, state and local cash assistance programs that provide benefits for income maintenance. So every state has a different one. Look into it. It comes under general assistance programs. We also consider an applicant's institutionalization for long-term care at government expense, such as nursing home facilities, mental health institutions. If you're not paying for this, if the government is paying for it, then this will definitely affect your green card. Next slide. Now we will look at certain factors that don't affect your green card. People think that any benefit that you take from the government will affect your green card. That is not true. Nutritional programs, health programs, housing programs, meaning you don't have a house, you're homeless and you're provided a house. Education and child care programs. So there's a lot of health insurance available, free health insurance for children and for pregnant mothers. That is not considered under public assistance, public charge. Education, so if your child goes to public school, that is not considered under public charge. Nutritional programs, if they're providing nutrition, that is not considered. If you're taking a COVID vaccine, which is free, because the government provides that assistance, that is not considered as a public charge. If you take food stamps, that is not considered as a public charge. Next slide. So that's our list of what is a public charge and what is not. And it's always important, if you're in doubt, to check the regulation to see. There's a long list. Again, we couldn't cover all of them, but it's important to check and see. But just one thing to remember, if you're taking money from the government, or if you're institutionalized, then it might be considered to be a public charge. If you're taking assistance in kind, such as health insurance, housing assistance, food stamps, that may not be considered to be a public charge. Okay, so now in order to file a green card, we are looking at the steps. And so we saw that an I-130 had to be filed. Once the I-130 is filed, what do we do next? So if the person is in the country, we file for a 485. And this is applicant again for employment-based cases as well. So in order to file for a 485, there are certain eligibility requirements. Not everybody can file for a 485, even though they've lived in this country in the past, but they're not living now. They might think that, oh, we're out of the country, we can file. They cannot. So some people who are in the country still cannot file a 485 because they may not have been admitted into the country, or they may be out of status. So first criteria, you have to be inspected or admitted into the US, or inspected and paroled into the US. So you can come here on advance parole, or you can come here on some non-immigrant status. Either way, that is admitted or paroled. So you can, as long as that has happened, you've entered legally, you can file your 485. Must properly file an adjustment of status application, meaning you have to file a proper 485 application with the proper fee and send it to the right address. Must be physically present in the US. So as I said, if you're out of the country, even if it's for a 1 month, you want to file your 485 while you're on vacation outside the country, you cannot. You have to come back and then file. You must be eligible to receive an immigrant visa petition, meaning you should have filed an I-130 petition, and it should either be approved or it should be pending, but you should meet the requirements of getting an I-130 approved, at least the preliminary requirements, meaning that there should be some basis on which you filed an I-130, and it should be a valid basis, meaning that it could be family-based. If it's an I-130, if it's an I-140, it can be employment-based. An immigrant visa number must be immediately available. We are talking about the visa number, the green card numbers. We looked at the charts earlier on, and we saw that for immediate relatives, the visa numbers are available. For some employment-based cases, visa numbers are available, not for all. So your visa number has to be available in order to file the 485. So you should qualify either based on dates for filing chart or the final action dates chart. Must be admitted to the US for lawful permanent residents or eligible for a waiver of inadmissibility or other forms of relief. So you should not be inadmissible. If you're inadmissible, then you should, some kind of a waiver should be available for you. And of course, USCIS has the discretion to approve or deny your 485 based on various factors, one of them being the public charge grounds. That's one of the grounds of inadmissibility as well. Another ground for inadmissibility could be that you committed some kind of a crime, and there is no waiver for it. For example, you've committed a felony. Unless you file a waiver and you are eligible for a waiver, you will not be able to file a 485. If you've committed a misdemeanor, you might fall under one of the exceptions of petty offenses, and you might be able to still file a green card or a 485. So you have to go more in depth to understand this, but this is just a bird's eye view. Next slide. For those people who are not in the country, they have to file consular processing. Again, this is true for family-based or for employment-based cases. The beneficiaries residing outside, they have to, the following steps have to be done. First stage in consular processing is to see if you are eligible to apply for a green card. That is, filing an I-130 on some basis or the other, which we already covered. Next slide. You have to file an immigrant petition, which is the I-130. You have to wait for the decision on the immigrant petition to see whether it gets approved or not. Once the I-130 gets approved, then that notification is sent directly to the National Visa Center. It's called NVC. And the National Visa Center will keep the petition until your visa number becomes available. That means until your priority date becomes available. The National NVC will just hang on to that immigrant petition. So once the priority date becomes available, the NVC will contact you via email or via mail, regular mail as well, and they will then ask you for a list of documents. And this is done online. So you have to actually pay the fee and submit those documents online. The documents are similar to a 485 document. So in a 485 and here as well, you have to show that the sponsor can support you. That's an affidavit of support, like we discussed that earlier in the public charge section of the presentation. You have to submit your status. If you're on a 485, here there is no status, so you just submit your copy of your passport. You have to submit proof of relationship in both the 485 as well as with the NVC. So that could be a birth certificate or a marriage certificate. If you don't have those documents, then there are secondary documents that you'll be able to submit, such as affidavits, letters from the hospital, you know, these kind of documents to show proof of relationship. And also you have to submit the proper fee, as I was mentioning earlier. And next slide. After the NVC collects all those documents, the NVC will notify you that your case is completed, and they will then submit, if the visa number is available again, they will then send all the information to the consulate because you're outside the country. Then the consulate will notify you by mail and invite you for an interview, ask you to come for an interview. And at the interview, you have to take all your original documents. And once you submit all the original documents, they conduct the interview. Most often, you will have the sponsor will also have to go for the interview. The person who's sponsoring you, so your U.S. citizen spouse or your U.S. citizen parent or whoever that might be, they have to go for the interview as well with you. And once the consulate is satisfied that they have all the documentation, they will then approve your case. And so make sure that before that, if there's any changes to your information, you notify NVC before you go to the consulate itself. So next slide. The consulate approves your case, you will basically be given a visa. It's called an immigrant visa. It's an immigrant visa packet. It's sealed. You don't open it. You take that and travel, go to the port of entry at the airport. At the airport, they will process you for a green card. They will take all the information. They'll take the fee, take the biometrics. And then what will happen is they will allow you in on this green card immigrant visa. And then you will get the actual green card in the mail after a few weeks or a few months. And then you'll officially be a green card holder. So these are the steps involved in this process. I think that's the end of the presentation.
Yes, that's correct. So now we are opening the session up for Q&A. Now is the time. If you have any questions, it could be green card related and or any other visa for that matter. Please drop in your question. So Prashanthi, while we have this panel drop in their questions, we have a few that we've received offline. So I'll go ahead and share a couple of them. And again, keeping a close eye on the timeline here, we have about 8 minutes left. One of the questions we've got is, I currently live in Canada with my wife and kids. I'm a Canadian citizen. My wife is an American originally, but now has her Canadian citizenship as well. My 4 young kids are all dual citizens of Canada and the US. We are looking to move to Nashville area. What's the fastest way to move to the US so I can stay down there permanently for now? Is it faster to apply from within the US to get a permit or green card? As I know from applying from Canada to get a green card, it's around 12 to 16 months, as I met with an American immigration lawyer a couple of years ago.
So this person wants to apply for a green card through his spouse, who is a US citizen. but the spouse who's a US citizen is not residing in the US. So it's important that the spouse take up residence in the US first, and then the spouse can apply for the rest of the family members. It is faster to apply while you're in the US. However, I would caution you that when you're entering into the US, if you have an intent to immigrate and you come on a visa waiver, or visitor's visa, your intent becomes an issue. So if you apply for the green card as soon as you enter, they might uh, bring that into question, and they might question your entry itself into the US and say that you are not lawfully admitted. So I would not, if you're planning to come into the US and then adjust, then I would not do that immediately. Wait for a 90-day period or longer before I file for adjustment of status. That way you can at least justify that, you didn't have the intent of doing it at the time of entry, if that makes sense. So that's, the best way. The fastest way is, I mean, not necessarily the fastest, but the adjustment of status in the US is beneficial because you're already in the US during that period of time. You can remain in the US while your 485 is pending. You get EAD, which will allow you to work. So you have advance parole. So you're not wasting any time really. And since you're already in the US. If you do it while you're outside the US, while the advantage is that there's no intent issue, you won't be able to come into the US until the green card is actually approved. That could take some time because of delays at the consulate. So even though the NVC process might be smooth, the consular processing is always different depending on the consulate that you go to, because it depends on how much traffic they have there. So, there are advantages and disadvantages to both.
All right, thank you. I'll have one more question answered here. Entered the US a few weeks ago on TN visa. Please help me understand the path to green card for an Indian-born Canadian. TN category sales engineer with 2 degrees and 13 years of experience. The company is relatively new, but they're looking for more information. Is there a way to get green card before my next renewal?
If you're an Indian national, no, there's no way of getting it. If you're born in India, it doesn't matter which country you have citizenship from. As I told you earlier, it's country of birth, not citizenship. So on a TN, you have to follow the regular route. You have to file a labor cert, file the I-140, and then file the 485, and then wait for your number to become available, visa number, as we're discussing throughout this presentation. And then you'll be able to file the 485 and get a green card subsequently. So that's the path that you have to follow. Unless you have a family member, like we were discussing in this panel, you have an immediate relative, US citizen or permanent resident, or you qualify under the other preference relative categories, then you can go to the, get a green card based on that family-based visa. Or you can file for EB5, which is the entrepreneurial visa, investor visa. You can do that as well if you've invested a certain amount of money in the US. So these are the, different categories available for anyone who's in the US in a non-immigrant status.
All right, Prashanthi, that's all the time that we have for Q&A. I'll quickly let our audience know that we can help you with your immigration requirements in a number of ways. So feel free to reach out to us. So on that note, we would be wrapping up the session.